There may be a serious flaw in the case against Tommy Robinson regarding this injunction. You may have seen his video online where he says that it wasn't properly served and wondering what that's about. I've been tagged in it, so I thought I'd explain it for you. But first, if I could ask you one quick favour, about 60% of people that watch my channel don't subscribe. I'd love it if you did, because I like to demystify these things for you, explain them in as simple terms as I can, and I'll tell you what a lot of the mainstream media won't say. Because I doubt very much the mainstream media will be talking about this in exactly this way. So I'd really appreciate that, so thank you very much. So let's get into it. Let me give you an idea, first of all, of what service really means. You see, when you sue somebody or you are sued, there is what we call service. That is just giving somebody notice, sending them the documents, and so they have to have those documents in order to be able to consider them properly, and then these time frames, the time limits kick in. For example, if you're sued on a very straightforward claim, you have to be served properly, i.e. you've got a service of the claim form, which is literally just a form that tells you what the claim is about. Then you have service of the particulars of claim, which is the details of the claim against you. Obviously, if you haven't received those on a specific date, then how can you really have a time frame and a deadline within which to comply and respond to it? So it's got to be served properly. And from that point, there's a time frame. And with a normal claim, you have to respond within 14 days. If you acknowledge service, that means you say, okay, I've got the documents. Then you get another 14 days to respond to them. So you get a total of 28 days, generally in the civil courts. However, let's just have a brief look at methods of service, because there are different ways of serving these documents on other people. There are, first of all, personal service. That is, you hand it to somebody and you sign something. It's a certificate of service. You'll be familiar with the phrase of a process server. That is a company or a person who is in the business of personally serving documents, and they sign a statement and everything else to prove that it has been served personally on that person. Secondly, most commonly, we have first-class post. You don't need to send it by registered delivery or special delivery or anything like that. You just put it in first-class post, and that is considered to be good service. There are other time frames, etc., which kick in, but I won't go into those in this video. Leaving it at a place specified, faxing or electronic communication, or any other method that's authorized by the court. For example, we've had one case which is an emergency case for an injunction whereby a child was going to be kidnapped and removed from the UK. We actually had permission to serve notice of an application for a prohibitory injunction from removing the child from the country. We served it by WhatsApp because it was that important, it was that urgent. We had a judge on the phone in the evening to say we need service for this now. We had that, and that injunction was heard by telephone, and the injunction was granted to prevent this child from being removed from the country. We also had dispensation with service, which is something we'll come on to in this video, because personal service is something that is really important, because these parts of our civil procedurals, all of the rules that we're required to comply with when dealing with the court system and the justice system as a whole, we have parts which incorporate the rules, enactments, which is statutes of law. We have practice directions, which are essentially the guidance with how parties and the court is to comply with these rules. And then also we have court orders, which might provide for something, such as permission to not have to serve something personally. Now, that's really important in this case, particularly because if someone is going to be held in contempt of court, meaning you've failed to comply with an order of the court, you can be held in contempt, and the punishment for contempt is going to prison. It's not the same as an ordinary criminal offence. It's sort of a special thing all by itself. It's known as contempt of court. Deliberate and or willful refusal to comply with the court order can be contempt of court. One of the common examples is in the family courts, whereby the order is provided that the parties must provide access to the children on a given date, or they must drop them off to their partner and so on. Now, anyone that's been through the family courts will be aware of those. And on it, there's what we call a penal notice. A penal notice means if you don't comply with the terms of the order, you can be punished, either by being fined, having your assets seized, or even committed to prison. So all of those are important, because in order for someone to be held in contempt of court, firstly, there needs to be an application to hold them in contempt of court. Secondly, there needs to be a penal notice on the order. And thirdly, it needs to be the case that it's been personally served. Now, that is really important in this Tommy Robinson case for reasons I will come to in a moment, with an example of this very issue being discussed in the High Court by Mr. Justice Nicklin himself. And so just before we get into some more specifics about how these rules may apply in the Tommy Robinson case and how they might be argued on Monday, I do need to ask you for your support. You see, in order to continue bringing these videos and giving you an open, honest account, which the mainstream media possibly won't do on occasion, I do take partners to support my channel and growth here. So I'd like your support in supporting my partner. They will help you because they provide a fantastic service. Today's partner is Incogni, which will help to keep your data secure. So just bear with me for 60 seconds or so. Incogni is a service which will contact data brokers, which are companies that gather together all of your personal information, your name, your phone numbers, your email addresses, your home addresses, all sorts of information that you've searched for online and piece you together like a jigsaw puzzle, and then they sell you on to other parties. Not only does this mean that you get loads of junk calls, but it means you might be the victim of identity theft down the line. And ultimately, your information might end up on the dark web. Incogni is a service where you sign up and you instruct them. They contact all of these data brokers. They use UK and US law to require they remove your data from their servers, and they are no longer legally allowed to sell it on. If they do that, you've probably got grounds to sue them because you've asked them to remove that data. Now, if you want to be able to trace that data back to a given company, here's a little trick for you. If you use your email and then the plus sign and then the name of whatever company you're signing up with, not only will this still come to your email account, but it'll allow you to track where the email has been sold on to. But if you want to ensure that these companies remove your data from their servers, of course, I get you a fantastic discount with Incogni, which is 60% off an annual plan. The code is on screen. The link is in the description below. It will really support me if you support my partner and help to keep your data safe. So check out Incogni with this fantastic discount and money back guarantee. The link's in the description below, which is incogni.com/blackbelt, which has been on screen. So thank you for that. And now let's get into some analysis. So on the very strict caveat that none of this is to be taken as legal advice by anybody, much less Tommy Robinson, but he knows that. And moreover, it is not designed in any way to be predicting an outcome or anything else to do with this specific case. This is just generically how this applies in these kind of situations, because this is essentially what he's going through right now. When we look at an application for contempt, under Part 81 of the Civil Procedure Rules, there are requirements for an application for contempt of court. Now, just to give you an example of where this might happen is if I've previously had an order for a bank to pay money over to my client under what's known as a third-party debt order, and they just didn't do so. Weeks and weeks went by, and I think it was passed between different people within the bank. Somebody left or whatever the excuse was. The net result is they didn't pay it. And so I had no choice really but to serve them, to say we will be applying to the court to hold the board of directors of the bank in contempt of court for not complying with the terms of the order to pay the money to my client. They paid within 24 hours. So it does work, but there are certain requirements for that to happen. Now, under this application for contempt of court, a contempt application, reading under here, a contempt application must include statements of all of the following unless, in the case of B to G, they're wholly inapplicable. Now, the nature of the alleged contempt. Obviously, if you are alleged to be breaching the terms of an injunction to say, don't do this or you must do that, then obviously it must describe what that is. The date and the terms of any order that's allegedly been breached or disobeyed. Confirmation that such an order was personally served and the date that it was served, unless the court or the parties dispense with personal service. And so this application needs to have confirmation that any such order that they say has been breached has been personally served, unless the court has said we don't need personal service. Now, the court does have a very broad discretion to dispense with service, but it is not normally retrospective. It doesn't normally apply to what's happened before. It doesn't normally put right mistakes in the past, unless there are some very good reasons, which I'll come on to in just a moment. If the court dispensed with personal service, the terms of the date of the order dispensing personal service must be included. So, in other words, if the application says, well, it wasn't personally served, but here's an order from the judge previously that said we don't need to personally serve it, then that's usually fine. I've had a case just recently, which I'm going to talk about in great detail in the coming weeks or months, whereby a judge granted permission going forwards but not retrospectively to serve things by email, because typically you might want to do that if you don't know where someone lives, you don't know what the address is, or you know that they are not at an address and things like that. Then obviously that might be a problem. But let's come to one particular case which was exactly this sort of scenario, and it's this case here. And again, as I say, in the High Court by Mr. Justice Nicklin himself. Jumping to the bit where they talk about all of this, this is the argument here, which is broadly similar. I'm not saying exactly the same, but it's broadly similar to what we've got here in this very case. And as I say, I'm speaking generally, not making predictions here about Tommy's particular case. But under this bit here, in light of the evidence about Miss Laidlaw's knowledge of the terms of the injunction, the court should dispense with the requirement that the injunction be served upon her. That's a question posed by within this judgment. And the judge says here, the court does have a wide discretion to dispense with defects of service of an injunction order. So the court has the discretion to say, well, it wasn't served properly, but that doesn't matter for reasons. And then there's various authorities here that the court goes through to discuss this, and says that these decisions contain useful review of the authorities, and when it would nevertheless be just to dispense with the requirements of an injunction order to be served. One category, the judge says, I'm reading from the orange highlights here, one category which has been long recognised in respect of prohibitory injunctions. A prohibitory injunction is something where the court says you must not do this. Again, speaking generally, is where the court satisfied that the respondent knows the terms of the injunction. For example, because he or she was in court when the injunction was granted. So one party might say, well, we would invite the court to dispense with this need for personal service because they were in court at the time. Now, one argument counter to that might be, well, just because they were in court doesn't mean they were paying attention. You may have been fazed by the situation. You may have been confused by the situation. You may not have understood the situation. It may not have been explained properly. You may have been looking out the window. Or it was all explained to you, but you just didn't get it, and therefore you were not sure of it. So there's all sorts of arguments that could be had there. The judge said the Court of Appeal was satisfied in this case that the defendant knew precisely the terms of the order, in the case referenced here, this Hill, Samuel and Co., and that it was just in the circumstances for the judge to have dispensed with service of the injunction order. So in that case, the Hill Samuel case that's quoted here, the judge in that case said, well, the defendant knew precisely what they were told not to do, and therefore it was just in those circumstances for the judge to say there was no need for personal service of the injunction. However, in this case here, the judge says, in my judgment, the authorities show that the key question, if the court is considering retrospectively dispensing with a requirement to serve an injunction order, is whether the court is satisfied, and here's the real key point, whether the court is satisfied to the criminal standard, that's beyond any reasonable doubt, also that you are absolutely sure that the material terms of that injunction order said to have been breached were effectively communicated to the defendant. And so let's take an abstract example. Let's say an injunction said to a musician, don't play a certain song in a certain place or whatever. If the injunction said you must not play this song and doesn't specify when and where and what sort of cover or in what way, if it was in any way vague and they weren't really sure of the terms, then that might be one argument against it. If the injunction was absolutely crystal clear, you must not play this song in any way, shape or form on any instrument, anywhere, ever, for whatever reason, that would obviously be very clear. So you can see the two subtly, well, not subtly, quite different examples there. And so the cases, the judge says here, show that it's possible to demonstrate this by evidence in several ways. But the objective is clear, as are the statements in principle from the European Court of Human Rights. What is required, the judge said, is knowledge of the specific terms of the order, not its general character, not just generally you must not do this thing. The judge says here, concluding largely for the same reasons I've set out above, the evidence in this case that I'm reading here does not satisfy me that I'm sure, which is the criminal standard, that Miss Laidlaw had sufficient knowledge of the specific terms of the injunction to justify dispensing with the ordinary requirement that she's to be served with the injunction. On the contrary, and critically, the judge says, the evidence demonstrates that Miss Laidlaw was, at the material time, for the purposes of the first contempt application, mistaken about the width of the exclusion zone. You see, this was an injunction to stay out of a certain area, which also affects the issue of whether she was approaching and or obstructing vehicles that were directly entering that or exiting that zone. So it was to do with exclusion from a certain zone there. And in consequence, the judge concludes, I refuse to dispense with service of the injunction on Miss Laidlaw. And you can see from the very opening here, this was a judgment following an application for contempt made against these two respondents for alleged breaches of an injunction order. So, summarising all of that together, not commenting specifically on Tommy's case, speaking generally, in a case like this, the court would have to decide whether or not any defendant to a contempt application had the specific required knowledge of the terms of an injunction to the criminal standard to be held so that they could dispense with personal service. But what I do understand is that there'll be arguments as to whether the person was in court or whether that still counts by video link, and whether or not referring to an injunction constitutes specific knowledge of the terms of the injunction itself. All of those arguments are what is going to happen in court on Monday. Now, as I say, ordinarily, the court is going to be reluctant to grant retrospective permission to dispense with personal service. So the court is not usually likely to make good the errors of the past, rather more likely to do that going forward. Whereas it obviously depends on the circumstances here, all of things like specific knowledge of the details of the injunction, whether it was sufficiently clear and all those sorts of things. And obviously, without seeing the injunction itself, I can't comment too specifically because I haven't seen it. But those are the arguments that are likely to be had. And generally speaking, in a case like that, it is a very good argument, because to hold someone in contempt for breach of a court order is a very serious thing, because the result is you can go to prison. So I hope that served to shed some light on it. If you do enjoy my content, please do consider liking the video and subscribing down below, as always. And do check out Incognito. It's a fantastic service. I use it myself and I'd wholeheartedly recommend it. So thank you so much for watching, and I'll see you next time.